All right. Hello, Lyric Armstrong, your real estate agent and advocate. We are here today. We are going to go somewhere new, the far and beyond. Kind of, sort of. It's kind of going to be beyond. We're going into probate court. This is Chambers County in Texas. And I wanted to give you something a little different because we talked about Aretha Franklin not having a trust and having to go through probate just to determine which one of her wills would be the prevailing legal document. And so that took 5 years. That simple determination took 5 years. And probate can take around 2 years typically, but of course, could be up to 5 years, right? It's all depending on the circumstances. The reality that I want everyone to be highly cognizant of is when you have assets, whether they're personal property or real property is considered real estate, so that's what we call real property. Make sure you put all of those things in a trust. Where you send them to, who you give them to, what you give them to is no one's concern. We're not going to judge you. And even if we did judge you, so what? We can't pull you up from the grave and talk to you about why did you give it to the orphanage? Why did you give it to the church? Why did you give it to the dogs and the cats and everything else? We don't know and we don't care. There's nothing we can do about that. You can give it to whomever and whatever you want. If you have a nonprofit you want to give it to, great. The concern I have is when you don't have it delegated correctly, and you don't have it protected correctly, you put the items in a place of depreciation, like an automatic depreciation. Your estate becomes automatically depreciated when it starts going through probate, because anything that happens with the property or with the any of your assets, when they're litigated, it's due to a cost, right? It becomes a cost. It becomes something that the estate pays. And one of the things you want to know it's okay. One of the things you want to know on the upfront is when there is a litigation, the estate pays the attorney to defend the estate. So it's not just a matter of if your beneficiary or your loved one is challenging the estate, they are paying their lawyer fees. There's the estate itself it has to pay its lawyer fees to be represented. So you don't want to give any ambiguity to what your desires are. And since you'll be dead and you won't know what's going to happen if you just have a will, let's kind of look at what's going on with someone else's circumstance. And while we do that, I'm going to help little T'Challa here get situated. So let's get started. Once again, thank you to Chambers County, Texas. And this is their probate court. Press play or what?
Jimmy Rutledge Cotton.
Ooh, I can't hear that. Can you?
Yes, Your Honor.
Mr. Bart.
Ready, Your Honor.
Oh, yeah, we need. Thank you, Christy. Anyone that's going to testify, please raise your right hand so that we can swear you in.
Okay.
Good, Christy, you're muted.
My apologies.
All right. Anybody that's going to testify, raise your right hand, please.
Let's try this again. Do you solemnly swear or affirm the testimony you're giving today is true and correct, so help you God?
I do.
Thank you. You can put your hand down. And Counselor, you may proceed.
Okay, I first call Nancy Rodriguez. Please state your full name for the court.
Nancy Rodriguez.
And were you well acquainted with the family history of decedent Jim Cotton?
Yes.
And how long have you known Mr. Cotton?
Over 20 years.
And was Mr. Cotton married at the time of his death?
Yes.
Were any children born or adopted by Mr. Cotton?
Born or adopted? No, I don't think.
Okay. And to your knowledge, did Mr. Cotton have a will?
No.
And do you have any kind of financial interest in the estate?
No,
Now, Mr. Cotton had given up, or he had his rights terminated in a child, correct?
yes,
But you have no idea where that child is at,
no,
and so you don't know if that child is deceased. But that his rights to that child was terminated some 30 years ago, correct?
yes, 30 or more.
Okay, but as far as you know, his wife, and what is her name?
Why in Cotton?
Okay, and so he was married to her.
Yes,
Okay, I'll pass the witness, Your Honor.
Mr. Park, good morning.
Yes, ma'am. Are you aware of Starla Jean Cotton's, of her? Have you ever talked to her?
who?
The girl.
No,
No,
Do you know of her whereabouts?
I do not.
Have you talked to anybody that might know her whereabouts?
No,
You gotta love Zoom court. You gotta love Zoom. The attorney is like the girl in question, the chickadee who has come to claim her father's inheritance.
Other than the questions that have previously been asked you, do you have any other information that would lead us to any information that would assist us in finding her or any other error that he has?
no.
Okay. Pass the witness.
All right, call your next witness, counsel.
I call Paul McClure.
Yes, sir.
Okay, before they move on to the next witness, I was like, for real, like for real. But I'm not sure of the young lady's relationship to the deceased. Sounds like she is substantiating the fact that he was married, and she's professing that he gave up his rights to his child 30 plus years ago. And then it was really odd because one of the first questions was, did he have a child? And it was like, no. But yet, then you go into, didn't he give up his rights to his child? So he had a child and he gave up his rights to him. Which one is it? To me, two are not the same, but that's just me. That's my thought on it. The other thing is, gave up his rights how? Based on who and what? What tells you this? Like, what were we basing this on? It's just straightforward. No, yes, no. So this is one of the things that this particular family is going through. I don't know if his wife is still alive. I would presume so, considering there is some type of probate and concern for where his money will go to, or his property will go to. We'll see about it, his assets. But this is what happens. He didn't even have a will. Okay, so this is no will and no trust. This is all the way bad. So now this is what I want to have with, now look, come close. We're gonna have a side conversation. Usually I'm like really loud. I'm not gonna be so loud, okay? Because this is between me and you. Okay, we here. All right. I know there's some of you out there that might have a child on the side and you're not telling your wife, and whatever. This is what happens when you die. So if you want that child to be cared for, or to have any part of your estate, or at least legitimize them, something, give them some love, some kind of, that ain't their fault. You the one stepped out. They didn't do that. And it's go for women too, men and women. You got somebody on the side, I don't know how you did it, but you did it. Have a will and a trust. They cannot pull you out the grave and yell at you about the kid. They cannot. But don't make the kid suffer. Have a will and a trust. This is a cotton picking shame. And yes, I do mean cotton picking shame. And all the puns go along with it.
Would you please state your name for the record?
Paul McClure.
And were you well acquainted with the family history of decedent Jim Cotton?
How?
And how
How?
long did you know Mr.
How are
Cotton?
you acquainted?
For about 20 years. Okay, and
For the last 20 years. You understand this? So your best friends are coming up in here to talk about who, what should get your money. That could be a reliable source of people, but how much do you not tell people? For those of you out there who don't tell your best friends everything, and I mean everything that needs to be told, so when it goes to probate, things go in the right places. Let me put it to you this way: if you have something of value, say a house, and you don't have a person, you didn't tell them where to give it to, you didn't tell them to give to church or some other beneficiary, like that illegitimate child, or your wife's estate, or your brother, or his kids, or your cousins. If you don't have them to give it to, you don't put it in a will and a trust, it goes through probate. Well, the government will keep it. They'll take it, they'll sell it, and now the money is theirs and the house is sold to someone else. And maybe you don't care, but I just think it's much better to just give it away, maybe give it to a church, give it to a nonprofit, than to sit up and have the government go through all this process and all this money. Just wait, because they're gonna talk about it. They really, you just don't even understand.
was Mr. Cotton married at the time of his death? Yes, sir.
To have a will and a trust.
To your knowledge, did Mr. Cotton have a will?
No, sir, not to my knowledge.
And do you have a financial interest in this estate?
No, sir.
So why do we trust your accounting if he had a will or not, if you don't have a financial in the estate? Come on, Mr. Cotton, where's your will and trust, man?
There's he had a child, but his rights were terminated
So that's what,
to that child some 30.
and why? And then here's another thing, Mr. Patterson, he is totally testifying. He had a child and his rights were terminated. That's your testimony. What are you basing this off of? Has it been proven as such? Let the witness testify. What kind of such instruction? What kind of question is this? He had a child and his rights were terminated. Okay, were you there?
30 plus
Maybe,
years
well,
ago.
maybe he was. Maybe he was the attorney that terminated his. I don't know.
Do you know of that child?
I've never met the girl, never heard of her. I do.
That doesn't mean he terminated his rights. What are we basing this on?
She was adopted out or something, I don't know.
Okay, so
Adopted
your
out.
knowledge is limited to the fact that she was adopted out, but you've never seen her, you've never talked to her, and you don't know where she's at.
No,
Okay, so, oh wow. Oh wow. So the young lady was placed up for adoption. And if you have knowledge of adoption, then you know that the father gets the opportunity to claim his child, and he also gets the opportunity to say, no, I don't want my child adopted. I don't want my child sent away. They're professing that he, I guess, gave his rights away, said, no, I don't want this child. That's what they're professing. I don't know that if that's the case, because there are also times where the mother does not tell the father of her pregnancy, and because of whatever the relationship is, she will give up the child for adoption and say something like, I don't know who the father is. And maybe she doesn't know who the father is. Maybe that's one of the reasons she doesn't know who the father is. And then we have this great genealogy testing that we're doing these days, to where a child can now find their biological family based upon this testing. So I'm not saying these are these particular facts for this case, but I want to give you guys an understanding of what could possibly be your concern. Maybe you have gotten someone pregnant and didn't know it, and they have given the child up for adoption. And now this child has researched themselves and determined that they are yours, right? So hopefully, just hopefully, that's not the situation for you. And it's unfortunate for Miss Cotton that could be her situation. Doesn't mean that particular child, excuse me, has a right to your estate, because when they are adopted out, they become adopted into a new family. and they have the rights to the new family's estate. So atypically, they wouldn't be coming back for yours. But anyway, just think about that on the other side. How sad is that? You come to find out who your family is, got some understanding about where your bloodline originates or comes from, and they're telling you you're illegitimate and you don't have relation to this person.
Okay. I
That
pass the
outcome.
witness, Your Honor.
Mr. Park.
Yes. Mr. McClure, I've talked to you twice concerning this matter, correct?
Or talk to you twice. Oh, he talked to you.
Oh, yeah.
Can you come
okay.
closer?
Yeah.
This is so improper. The attorney should not be repeating the question, because any inference he could give can probably sway a witness's response. And he most likely has more comfort in connection with Mr. Patterson than he does Mr. Park. Just by the nature of what the case is. He's probably dealt with Gary Moore. Excuse me. So he just needs to come closer. Like, come closer, turn up the volume so that they can hear, because we don't want to have any impropriety going on with regards to his testimony. It needs to be clean and unscathed, but it's loosey-goosey today. It's okay. What we're here to learn about is what happens when we don't have a will nor a trust, especially when we don't have a trust. In this instance, they don't even have a will.
Yes, I've talked to you about this matter twice. Any further?
He's talked to you twice about this matter.
He said he talked to you twice.
Yes.
Now we got somebody. We got three people interpreting it. He talked to you twice. He talked to you twice. Did he talk to you
Or do I
twice?
remember? Yes.
Okay. And during our conversation, has any information come to your knowledge that would change the conversation that we had to allow discovery of this child?
No, sir.
Okay.
I still don't know.
Have you heard anything since the time that I've talked to you that would lead you to believe that there are any other children that he had? That's the witness, Your Honor.
Hi, Counsel.
Okay, so I don't know. That was like a nothing burger, and I guess it's just confirming that he doesn't have any new information about the whereabouts of the child, so that gives that confirmation, testifying under oath to that effect. But somehow, somewhere, someone has asserted that this person's in existence. Otherwise, how are we probating this? So who was that?
Nothing, Your Honor, nothing else. We, other than we need to get the fee of what Mr. Park's fee is, so I can put in the order. But I got to send you an order, because we have the estate's only about $50,000. And so there's a small house where the roof is leaking. And it's since we both been unable to find this, I don't even know if she's alive or anything. And Mr. Parks has been looking and checking for many months. So I think that we have proved up she's the only heir to this estate, and would submit an order. I don't have an order today, but I'd submit an order to you with the ad litem's fees.
Let me interject.
Yeah. Are you through, Counselor?
No.
Mr. Patterson, are you through? No,
Yes.
hang on a minute, Mr. Park.
Yeah.
Okay,
Yes,
go ahead, Mr. Park.
Usually our fee for Chambers County is around $500. If you approve that.
Did you hear that, Mr. Patterson?
Yes, that's not a problem, Your Honor. Whatever the court wants to enter is fine, Your Honor.
All right, so I do have a judgment declaring heresy. Mr. Parker, have you seen it and do you agree?
Okay, before they get too far down the legal, just wanted to make sure you heard that. So Mr. Patterson is saying the guardian ad litem. So that's Mr. Park. He's not necessarily an attorney, he's a guardian ad litem. He's in representation of the child, Miss Charlotte Cotton, whomever she is. They are both bringing before the court. They have not been able to locate this particular beneficiary. But one of the things I wanted you to see is that Mr. Patterson is an attorney, and then you have the guardian ad litem, and then all the filing fees that are just looking into this one scenario, this one situation relative to this probate case. And he's saying, okay, my fees are $500, whatever Mr. Patterson's fees are, and the estate itself is only have a value worth of about $50,000, and it seems to be real property. So under what I know is that, you know, Gary Patterson and Mr. Parks are going to need their financial payments, and they're not necessarily looking to keep real property. So it may even have to put the estate in a place where they have to sell the real property in order to pay, they have to liquidate the real property in order to pay something as small as $500, at least on one side. I don't know how much Gary's going to come out to be, but this is what I'm saying. You are either cutting your estate by having to sell off your real property because you don't have liquidated funds to help fund the estate for, you know, situations such as this, or you're finding yourself with high fees. I don't think there's going to be too many high fees in this particular circumstance, but anything, any fee, any court cost that you can avoid, you should. And it's very simple. Put a trust together. Just to have a trust, a will and a trust. These items, keep it simple. You're not waiting up to 5 years like Aretha Franklin's beneficiaries or heirs had to do. And you're not sitting up here cutting your funds and messing around with your estate value is what's getting ready to happen here. And hopefully, I don't know this to be the case, but they just might be in a situation where they have to liquidate something as with a very small value, such as $50,000, just so they can pay something, you know, even smaller off, just because there is no liquid funds to pay it. And you may say, oh, $50,000, who cares? Let me tell you something. A leaky roof is better than no roof. Okay? So you can fix a leaky roof. Get up there and fix that. You can rent that property out and have some money to live off of. This is how generational wealth is built. It's not the $5 million houses. That's not just the only house they will build generational wealth. Yes, $50,000 house worth will build generational wealth under circumstances necessary to be put in place. This does not cover that. It doesn't have a trust. There's nothing else to keep. There's nothing to pay the taxes with it. You know, there's no funds there sounding like there's no excuse me, no insurance payments upon the death. So they seemingly didn't have much planning going on when it came down to their death. But you have the chance to plan for you and your family, to get your life insurance in place, your iniquities in place, so that you can, annuities in place, so that you can have funding for the property, for the trust, so that you can have funds to pay the taxes on the property, do the upkeep on the property, so the heirs are of age to manage the property on their own, or whatever have you, whatever your setup is, right? Talk to a trust attorney for all the details. But yeah, this is going to be quite unfortunate if they have to sell this house just to pay these two representatives, one attorney and one ad litem.
Agree with the judgment?
I think they were going to email it to me. I haven't seen it, but
Okay, so
I'll
here's what I
find
want you to do. I want you to draft a judgment declaring heirship. Go ahead and put the fee in it and a place where Mr. Park can sign off on it that he's agreed to the judgment, and get it over and we'll get it signed.
Okay, I'll get that today, Your Honor.
Okay, Mr. Park, you good over there?
thank you, sir.
But in the meantime, I'm approving the judgment declaring heirship once that item is signed off on.
Okay.
Thank you.
Thank you.
Maybe
So you don't, that's all you need is the judgment declaring heirship, correct?
Yeah, I'm gonna do the, I feel since the estate is such a small estate, then after I do the heirship, I can roll it over to a small estate affidavit
Okay.
and do it that way, other than an administration.
Okay,
independent.
sounds good.
Okay,
Appreciate it.
So administrative estate means there are complications, such as you have maybe a couple properties, a couple of different pieces of assets, and you need an administrator, someone that is paid by the estate by the hour to, take care of these things. So maybe they're paying the gardener to keep up the properties, if you have more than one, and maybe they're having to pay and they go and they deal with finding things in the home so they can be appraised for value. They hire an appraiser. They don't do it themselves, but they hire an appraiser to do it. The estate pays for all of that. And, that's kind of what happened with Aretha Franklin. Her niece was the administrator, or she was acting as the executor of the estate. So she went through and was able to find the 2 wills. And that's how that became a question for probate in the first place. Because when she first passed away, they didn't think she had a will. Hello, they didn't think she had a will. Everyone said no, she didn't have a will for 9 months. It took before they actually found 2 wills. She had one in a locked case, and she had one in her like chair, or some type of furniture that she sits on or lays on. And so that's the whole problem with it all. Right? We got these people here saying, no, he didn't have a will. We didn't know of any will. No one told us of any will. And I hope he didn't have one, because they're getting ready to seem like they're going to award the wife, the surviving spouse, heirship. That's what they're saying, that she's going to be the heir of whatever the estate will be. And the valuation so far is $50,000, minus all the cost and fees.
Have a good day.
thank you, Your Honor.
All right, cause number 15, the state of Mary, excuse me, Mary Jane Dawson. Mr. Thompson.
Okay, they're calling another case.
I saw Ryan Thompson. Oh, there he is. Mr. Thompson, you on?
Judge, he's just visiting. He's actually on the next docket. He's new to chambers.
Well, this is on the docket. Are we moving it to the next docket?
Yes, it was actually set for the 16th. He just wanted to view how the process works for this one.
Okay, so we will not
So
be
just-
hearing anything on it today.
Correct.
All right, thank you, ma'am.
Okay, so I guess Ryan Thompson, either he's an ad liam or an attorney, and he's checking out what's going on in court just to see, how things are unfolding, so that when he does present next time, he can.
All right, call number 28, the state of Francis Leonard Hughes.
Morning, Judge.
Wilson, good morning. You may proceed, Counselor.
All right, we're to probate the holographic will for Francis Leonard Hughes, and we're requesting letters of independent administration. I think I need to get my witnesses sworn in, Your Honor, or was that for everyone at the beginning?
Well, did we swear your witnesses in? Let's go ahead and swear them in. If you'll
Okay.
raise your right hand.
All right, guys.
Do you solemnly swear or affirm the testimony you're giving today is true and correct, so help you God?
Yes.
I do. All right, you can put your hand down, Counselor. You may proceed.
All right, so first I'm gonna prove up the proof of death, Your Honor, and that's gonna be with Mr. Will Hughes.
Okay, you may
Mr.
proceed.
Hughes, is it true that Francis Leonard Hughes died on December 23rd, 2022 in Anahuac, Chambers County, Texas, at the age of 87?
Yes.
Was the decedent a resident of Texas and had domiciled a fixed place of residence in Chambers County?
Yes.
Before you is a document, a file stamp document dated May 22nd, 2010, and that purports to be the decedent's will. And to your knowledge, it was never revoked. All right. All right. Now, looking at that document in the entirety of it, does it appear to be in his handwriting?
Oh, yes.
And is that his signature?
Yes.
Okay. Is there a necessity to?
And so just picking out similarities, just so that we can understand things that are happening. The holographic element of a holographic will, that means that it's within the decedent's handwriting. So that's what he just did, was work towards legitimizing the handwriting to confirm that that was this particular decedent's handwriting. And this does align as well with Aretha Franklin. Hers were holographic as well. And I do caution individuals on that regard, just because same with Aretha Franklin's will, there was, you know, a lot of formatting thoughts, like things in the, you know, all around the paper seemed a lot like scratch paper. However, the elements of a will were there. And in some parts, it's like, can you make this out or can you not? You know, so the individuals who are, you know, trained in linguistics, or at least individuals who are trained in holographic will reading will definitely have to deal with, what does this say, right? It's like, we're great. They picked the will. We know which document's going to be the enforceable document. However, what does the document say? Now that is in turn the newfound discovery that needs to go forth. And how many hours is that going to take? And how much money is that going to take? All of that is going to go come out of the estate's funding. The estate's going to fund for it. The format of a will doesn't have to be typewritten. I just say, don't make people guess, because they might get it wrong. So when you type it up and have it formalized and read it over and ensure it says what you want it to say, everyone who has the ability to read that language will be able to read what it says and not have any ambiguity as to what you meant in trying to read your handwriting. Another thing is, my kids is of the generation that handwriting is not a requirement in school. And I mean, not handwriting, cursive. And so when I write their birthday cards and I write their notes, they're like, wait, what does this say? What does that say? And I'm like, are you kidding me? You know, it's a simple word, you know, that's this or whatever. And so I hope we don't get too far down generations that reading cursive is somehow a specialty. It seems to be such a simple thing to do, but yet I don't know if they're, you know, if they're teaching children well enough so that they can be leaders of this free world to be able to read cursive, especially since a lot of our historical documents are in, you know, cursive print. So anyway, I digress. Just thought you'd get a kick out of that one. So let's move back to this.
To administrate this estate?
Yes.
Were there any children born or adopted by the decedent after the execution of this will?
No.
Was the decedent divorced after the execution of this will?
No.
Is a state or government agency, charitable organization named as a devisee in this will?
No.
Decedent did not receive, is it true that decedent did not receive Medicaid benefits on or after March 1st?
Absolutely not.
2005?
No, never.
Okay. Does the decedent's will name anyone to serve as an administrator of the estate?
No.
Mr. Hughes, are you qualified to serve as a personal representative of this estate and you have not been convicted of a felony?
Correct, yes.
No further questions, Your Honor.
The compound question. Is it yes to both? Just kidding. I hope that is yes to both. He has not been convicted.
For this witness.
Okay, call your next witness.
Call Mr. Rex Tunzi.
Morning, Rex.
Morning. All right, Mr. Tunzi. Before you is a document dated May 22nd, 2010, and it purports to be the final will of Mr. Francis Leonard Hughes Jr. Do you see that in front of you?
Yes.
Have you reviewed that document?
Yes.
To your knowledge and your experience working, well, what's your experience with Mr. Hughes? How do you know him?
I used to approve his designs when I worked for Chambers County. He submitted sanitary signs.
Gotcha.
Signs.
Thank you. So after reviewing that document and the signature at the bottom, do you have any doubt that it's not completely written by the hand of Francis Leonard Hughes Jr.?
It's his writing.
It's his writing. All right. No further questions from this witness, Your Honor.
All right, call your next witness, Counselor.
That's all we have, Your Honor. The estate does not, the will does not put forth for an independent administration, though we have Mr. Hughes, who is a beneficiary, who's requesting an independent administration. He's also requesting that he be placed as the administrator for of this estate. He lives in Chambers County. He would be able to have access to the courts to be able to take care of this. Furthermore, the only other beneficiary of the will is a sister Susan Christopher. She has an affidavit signed. She also states that she would like William Hughes here to act as the administrator.
Oh, now, isn't that precious? When a brother and a sister can get along and say, yeah, I want him to be the administrator, because the administrator gets paid for their duties. So yeah, I want him to be an administrator. I love it.
Of the estate, and I will be filing that with the court today. And other than that, Your Honor, we're asking that you approve the probate of the holographic will, and you approve the independent administration of this estate, and you appoint William Hughes as the administrator.
So done. Then you'll get that to the court
Absolutely.
along with
Absolutely, Your Honor. All
the
documents will
rest
be
of the paperwork
forwarded.
needs to be done. Okay, thank you all.
Thank you.
Thanks, Judge.
All right. So that case is, well, that matter of the case is done. And as you may, have any knowledge about, if you dealt with court at all, everything is taken piece by piece. So that's just one of God knows how many more times they have to go before the judge. And every time the attorney has to go before the judge and represent the estate, he charges the estate and has to be paid. Now, if they have an administrator is put forth who's also a beneficiary, but because he's playing the role as the administrator, which is done, it can be done and allocated within the will itself. This time it wasn't, and so the judge has appointed him as such because he has requested it, and the other beneficiary has requested it as well. So she hasn't objected to her brother being the administrator. So he's going to be the administrator of the estate, and anytime they go before the judge to represent what's going on, and ever so often you have to go and say, okay, this is what's happening with this house. It's being brought up to code, or it's been cleaned out, or the assets have been assessed. Here's the assets, da da da. This is going on the market, yada yada. Whatever the updates are from one court date to another court date to another court date, the attorney gets paid and the administrator gets paid. The attorney gets paid and the administrator gets paid. So who pays them? The estate. The estate pays them. So this is why I say 1,000,000 times over, a will and a trust, not just the will, even though we've kind of graduated now. The first one did not have a will, and we saw how they had to look for many months for an illegitimate child that they represent, that the father did not have any rights to, but they still looked for them, and they had to hire an ad litem for it. It was a court-appointed ad litem. They thankfully are only $500 cost, but still it's a cost, and it's months. It's months looking for potential heirs, and that becomes a fruitless tree. And now I think it's the wife that they are awarding as the heir. They end up awarding someone as the heir, and they'll get the property. They've been waiting for months. That's on the good side. Aretha Franklin, they're waiting for 5 years, and they still haven't cut a check. They still haven't given stuff out. So wait you shall if you are in probate.
Have a good day.
You too.
All right, calls number 32, the state of Billy J. Tibbs.
Good morning, Your Honor.
Good morning, Mr. Ford. How are you?
Fine, sir. I'll be the witness.
And go ahead, Christy.
Well,
You're muted, Christy.
she's trying to
Oh,
find.
you know that?
I'm working on 3 screens and
I got you, girl.
Can you figure out which screen?
my apologies. Do you solemnly swear or affirm the testimony you're giving today is true and correct, so help you God?
I do.
And you may
Thank you.
proceed, Counsel.
Your Honor, Billy J. Tibbs died on November the 23rd of 2016 in here in Chambers County. She had her fixed place of residence at 7118 Chickasaw Street in Baytown, Chambers County, Texas. Had him before her death. And the document that's dated March the 12th of 2002, which is in file with the court, is her last will and testament and has never been revoked as far as I know. And there were no children born to or adopted by her after she wrote the will, and she was not divorced after she signed the will. She was married to James Tibbs, Your Honor, on the date that she wrote the will and on the date of her death, and that was her only marriage to Mr. Tibbs, to James Tibbs. There are no unpaid debts owing on the estate, and there's no necessity for administration, Your Honor. And she did not apply for or receive any Medicaid benefits after March 1st of 2005. And no state governmental agency, state or charitable organization was named by.
We are learning things. Oh, this was such a great find. This little this particular hearing set has been a great find. We've learned all kinds of different things. This individual, I believe he's an attorney, Jim DeFoyd, is representing the estate of Mrs. Tibbs. And Mr. Tibbs is the surviving spouse. There are no kids. They don't need an administrator. So we kind of understand what that means. He just asserted that she did not have any benefits from Medicaid after a certain date. And I'm not sure how far back it goes. So that's something that you'll have to ask an attorney about, is if it's at any point in your life did you receive benefits from Medicaid, or if it's in the last few years prior to your death did you receive benefits from Medicaid, whatever the situation. But guess what? They just reminded me, if you receive benefits from Medicaid, you go to probate, you have to pay it back. You're dead, but your estate has to pay whatever benefits you received from Medicaid back. Okay. Oh, and what's Medicaid? Okay, Medicaid is like Medi-Cal. It's like health insurance benefits from the state. This particular state is Texas.
Her as a devotee in the will, and Your Honor, we're asking. And no state governmental agency, state or charitable organization was named by her as a devotee in the will. And Your Honor, we're asking the court to admit this probate as funeral title only in this case. Thank you.
All right. So done. Thank you, Counselor.
May I be excused?
You may be.
Thank you.
Thank you. All right, calls number.
Oh, they're flying through this docket. So this is like first appearance that we just witnessed. They gave the rundown of what the probate is, and they're asked the court to receive it as a probate matter so that they can probate the estate. So guess what? He gets paid for this day. And every other day he comes out to court to talk about the case. And all he did now is say, we only have one person. We only have a surviving spouse who we have no heirs outside of the surviving spouse. That should be her heir. Okay, so why couldn't you just have that in your will and your trust versus having to take it to probate and now you got to pay these fees?
40,
Just
last
me.
but not
That's my thought.
least. Good morning, Counselor.
Good morning, Judge.
Have we sworn you in?
Not yet.
All right.
I'm ready.
She
Do you
better-
solemnly swear or affirm the testimony you're giving today is true and correct, so help you God?
I do.
And you may proceed, Counselor.
Your Honor, I'm here on behalf of the estate of Samuel Johnson. Mr. Johnson passed away on March 27th,
Uh-oh.
2023
Hold on, guys.
in Chambers County, Texas. At the time, passed away on March 27th, 2023 in Chambers County, Texas. At the time of his death, he had a fixed place of residence and domicile in Baytown, Chambers County, Texas. He died leaving a will, which has been filed with the court, dated January the 6th of 2021. To the best of my knowledge, that will was not revoked after its execution. He was not married or had any children born to or adopted by him after the execution of the will. That will names Jennifer K. Griffith to serve as independent executor. Ms. Griffith is qualified and not disqualified from serving as independent executor. The will does not name any governmental entities or state agencies or charitable organizations as beneficiaries. And we'd ask that the will be admitted to probate and that Ms. Griffith be appointed to serve as independent executor without bond as provided by the will.
Everybody, Mr. Will of Probate and Grant Butler's testamentary. Thank you, Counselor.
Thank you, Judge. Have a good day.
Okay, lovely, lovely, lovely. One of the extra tidbits we got there was without bond, right? So it's like, oh, what's that about? So when you become an administrator, and say you are not appointed by the family or you don't have relation to the family in any way, you can be in court as an administrator with the qualifications of one. And if the court doesn't have if the family doesn't have someone that can be an administrator, say they have a felony, right? So say you want your son, he has a felony on his record, but you want him to be the administrator of your estate. They won't allow for that in probate. They will say he is disqualified. And then consequently, they will appoint an administrator. And if there's no one else within your family and that, is an immediate family that can be identified as an administrator that has no felonies and a good credit, should have a certain credit score in California. What Texas does or someone else, other state does, I can't speak to that. But you have to have a good credit score. You have to not have a felony. And if you don't qualify, no one doesn't qualify, then the court will appoint an administrator. And that appointment can be, one of their paralegals or just someone there, and they will typically be an administrator with bond, because therefore, if something should happen to the estate, then there's a bond coverage, just like any other, bond that you have to get for other licensed events. So that's just like a little nutshell tidbit. All particular questions, all specifics, please consult the professional in your area. This is not advice. This is not teachings. We're learning things, but I'm not teaching you anything. We are learning together, okay? And these are my suggestions, in my opinion, my commentary. To be my client, you need to have a signed written agreement with me. I do things with paper and pen, emails and things, but I do not give advice on YouTube. Okay, so this is just suggestion, and I can't represent you just from being here. I'd love to represent you, however. So let me know if you need any assistance. Otherwise, if you are not in the state of California, but you still need assistance, I can refer you to one of my colleagues. Lyric Armstrong here, and I am your real estate agent and advocate. Hope you learned something. Get that trust. Get a will and a trust. It's only a few more dollars more, and it's a lifesaver in the end. So please protect your interests. Don't let anyone else benefit from your estate than the people that you desire to have, people or entities that you desire to have the estate benefits. Okay? Lyric Armstrong, real estate agent and advocate. I shall see you later.